I'm the chair of the Administrative Conference of the United States that goes by ACUS. And I'm going to take just a minute or two to talk a little bit about what ACUS is, who we are, and what we do. ACUS is a independent, nonpartisan federal agency in the executive branch, the mission of which is simply to make government work better, or try to do that at least. Our statute tasks us with improving the fairness, accuracy, and efficiency of agency administrative process and procedure. The ACUS Assembly is a 101-member body, which includes representatives from 50 federal government agencies and dozens more scholars, practitioners, and other experts. It's the assembly that adopts the formal recommendations for action by agencies, the Congress, the judiciary, or the president. And it's those recommendations that you may be most familiar with. We also publish a range of resources, reports, studies, source books, reference guides, statements of principle, and the like. And we, of course, hold forums just like this one. This forum, the two-part series, has been an opportunity to hear from experts on the topic of universal relief. In our first panel, which was held last week on September 27th, our experts discussed a recently released report that was commissioned by ACUS on nationwide injunctions and particularly their effect on federal administrative programs. We hope that many of you were able to attend that session. If you missed it, the recording video is available on our website. Today, we conclude our forum on nationwide injunctions with a panel that will discuss broader legal principles of universal remedies, how judicial precedents in other areas, such as standing, inform the debate on universal remedies, and considerations for possible reforms of those remedies. I will end with thanks to our panelists and the ACUS staff who worked so hard to bring this panel and forum to you. A special thank you to our moderator for this panel, Adam White. Adam was a public member with ACUS for many years and is now a senior fellow. So he's a good friend of ours. He is the Lawrence H. Silverman Chair in Constitutional Governance and a senior fellow of the American Enterprise Institute. Adam also co-directs the Antonin Scalia Law School's C. Boyden Gray Center for the Study of the Administrative State. He also publishes, it seems, almost weekly in the Wall Street Journal, which I tease him about. So thank you for leading the conversation, Adam, and I look forward to the discussion.
Thanks, Andy. Thanks to the whole ACUS team for putting this together. I've been looking forward to this conversation, and we're lucky to be joined by three great speakers. Before I introduce them, I'll just reiterate that this is the second panel. The first panel, last week's panel, on the ACUS report on nationwide injunctions and federal regulatory programs is available still on the ACUS website. The YouTube video is available on the ACUS website, so if you haven't already seen it, please do check it out. Our conversation today is on the opportunities and challenges of universal relief. We'll build on the report by Zachary Clopton, Mila Sahoni, and Edward Stiglitz, and we'll build on last week's conversation. I'm sure we'll overlap a little bit with last week's conversation, but with three great minds and voices on the subject. I'll introduce them really briefly in alphabetical order. Jonathan Adler is the inaugural Johann Verhey Memorial Professor of Law at the Case Western Reserve School of Law, where he also directs the Coleman P. Burke Center for Environmental Law. Amanda Frost is the David Lurton Massey Jr. Professor of Law at the University of Virginia, where she also directs the law school's Immigration, Migration, and Human Rights program. And third, we're joined by Elisa Klein. She's an associate professor of law at the Wilmington University School of Law, where her scholarship focuses on administrative law, process, and remedies. She joined the faculty this year after serving for nearly 3 decades litigating cases in the Justice Department's Civil Division. So thanks, everybody, for joining us. I thought we'd start with just broad opening thoughts, big picture introductory thoughts, and then we'll dive into a number of the subjects. And, of course, we'll welcome the audience's questions. Please do submit your questions with the Q&A function. The ACUS team and I will keep an eye on them and try to get to as many questions as possible along the way. So without further ado, we'll start with Amanda. Amanda, big picture thoughts on the opportunities and challenges of universal relief.
Yes, thank you so much to ACUS for inviting me and for studying this important topic. I'm looking forward to the conversation with fellow panelists and answering any audience questions as well. So here are my big picture thoughts. So universal remedies have certainly been controversial as of late, and I think the fact that we've seen a shift in administrations has helped to put into stark relief for people on all sides of the political spectrum, the power of district courts to issue such injunctions. So I want to start first by defining terms, and I'm going to adopt the definition that Zach Clopton used in his presentation on the first ACUS video on this issue on Friday. So Zach said that by universal injunction or universal relief, what he meant and what the ACUS report was referring to were injunctions and other types of remedies issued against federal government defendants that seek to enjoin the government with respect to non-parties and without regard to where they are located. So even though they're often referred to as nationwide injunctions, it's really not about geographic scope. It's about the federal government being enjoined from enforcing a policy, not just against the plaintiff, but against all parties. And these have been criticized of late. There have been some law professors who said they're unconstitutional. A couple of the justices similarly suggested that. And there was a sense that they were being overused. And I will say my big picture take is that they are, in some cases, extremely and important, valuable forms of relief, essential to provide complete relief, essential to protect similarly situated people from irreparable harm, and frankly, also just essential to administrability, which I think the ACUS report supports. So I don't want to see them abandoned altogether. On the other hand, I think they were being overused. And I also think that part of the problem with universal injunctions is connected to problems in two other areas of the law that I know are our topics today. One is a very broad and expansive view of state standing. And in Massachusetts versus EPA back in 2007, the Supreme Court seemed to suggest states had special solicitude, was the phrase it used, in standing analysis. States, I think, were very aggressive under the last few administrations in suing to enjoin federal policies. And the Supreme Court seems to be backing away from some of the broadest views of state standing. And I'll happily go into the weeds on those cases when we get to that topic. So that's one problem that I think is very much linked with nationwide injunctions and universal relief, because if states have very broad standing to sue, for example, one argument was any additional immigrant into our state, even one, costs our state money, even if they also benefit our state. Eventually, they cost money, and that gives us standing. And the Supreme Court seemed to endorse that theory. Certainly, lower courts did in early litigation challenging deferred action for childhood arrivals and other programs. But they've stepped back, it seems, from that view in a recent case, United States versus Texas. So there's been some retrenchment there, and that might actually help curb some of the overuse of universal injunctions. And I'd prefer to see that than cutting back on universal injunctions. Another area very closely related is the question of choice of forum. There's been a lot of concern about the fact that in some states, in particular Texas, but it exists elsewhere, plaintiffs can choose not just the forum, but the actual judge by filing in a division where there's one judge. And while there's random case assignment, if there's one judge, you'll be randomly assigned to the one judge. So this idea of picking your own judge, I think, has undermined the judiciary, has led to some politicization of the judiciary, some sense that it's not law but politics, more than usual, maybe. And so there's been some effort. The Judicial Conference of the United States has suggested some reforms. I'll talk more about those in detail when we get to that question. But that might be another place where we, by cutting back on some of the plaintiff's ability to select the forum, as well as state standing, we could reach a result in which universal remedies are used more frequently when they're appropriate and not when they're inappropriate and overreach of power by a single district court judge. So I'll stop speaking there, but I look forward to getting into more detail when we get to those questions.
Great, thanks, Amanda. Elisa, any opening thoughts?
Sure. I very much agree with Amanda that thinking about these different doctrines together is really important and critical, and addressing universal remedies and isolation is only getting at piece of what we've been seeing in the courts. I'll just sort of start with my punchline perhaps from having spent my entire career defending federal agencies, is that, the Supreme Court is obviously keen on separation of powers nowadays. And it, basically sees a mission of keeping the other branches of the federal government in their respective lanes. And I really think it's time for them to do the same, clean house and keep lower federal court judges in their lanes. I'm going to just, for my own terminology, when I say universal remedy, I'm using it the way Mila Shahona used it in the first part of the forum, which is any order with universal relief. So it would include injunctions against the federal government, but it's not limited to that, because the vacator concept, or postponing the effective date of the rule, can have very dramatic consequences for non-parties that might want to enforce the rule in their independent private litigation. And I think that carries some due process concerns with it. So I'm using the term a little bit more broadly, but I don't see any disagreement there. And I just want to toss out two examples from over the decades that helped inform my thinking. And I'm using them in part because they aren't examples of forum shopping. These are very able judges. And I just want to spell out the way, first in the litigation in the Obama era, and then in a separate piece of litigation in the Trump era, what happened with universal remedies. So the first was the lower court litigation over the tax credits from Obamacare that the Supreme Court ultimately decided in King versus. And as probably many in our audience know, there was a circuit split that developed. So what happened was, it wasn't that easy for Jones Day and the like to find individuals to sue the IRS to say, please don't pay me subsidies. I see Jonathan laughing because I think you filed an amicus brief back then. And, they basically, in the DC Circuit case, it started in the district court, they've got David Klemenchik, who we all recognize because he was also one of the handful of individual plaintiffs in the original Supreme Court Obamacare case, NFIB. And we're like, he's back. So, he had a standing theory for why he was injured by getting the federal subsidies that were making health insurance affordable for about 7 million people at that time. And we had won in the district courts in a couple of places, and then we're up on appeal. And on the same day, hours apart, the Fourth Circuit issued its decision in King versus Burwell and upheld the IRS regulation. That was a suit, again, a small handful of individuals. A few hours before that, a divided panel of the DC Circuit reached the opposite conclusion. But what, for today's purposes, was striking is that Judge Griffith at the end said the IRS regulation is therefore vacated, and said enough to make clear he meant universally, so that not just in the minds of the DC Circuit panel majority would these subsidies stop flowing to David Klemenchik, redressing his own injury, but that 5 million people who were counting on these subsidies on an ongoing basis to pay for their health insurance, if the mandate had issued, were going to be cut off immediately. And the only reason that didn't happen is that we sought rehearing en banc, and the DC Circuit took it. Then the Supreme Court granted cert from the Fourth Circuit case, and everything in the lower courts got put on hold. So we never did have the kind of interruption that would have caused millions of people to lose their health insurance coverage. Scrolling forward in time to the example from the Trump administration, I'm pulling it out because it's sometimes held out as a poster child in favor of universal remedies, but I actually drew the opposite conclusion at the time. So this was a federal grant program, just called the Burn Jag program, in which Congress had made funds available to state governments and local governments for various law enforcement purposes. And during the Trump administration, the Attorney General, who was charged with administering the grants, attached various strings to them. for example, if, state government or local government took this money, they were supposed to then give ICE a heads up if they had someone in custody they were about to release and had reason to believe this was a person without documentation. So, and there were other things too, but the merits aren't the point. The point is, these strings were challenged in cases around the country, and the Seventh Circuit affirmed a nationwide preliminary injunction in which the district judge had said these strings are unlawful. But a couple of years later, the Second Circuit reached the opposite conclusion and said the strings were within statutory authority and not contrary to the Constitution. And all of the merits of that got overtaken by the change in administration. When the Biden administration came in, they just got rid of the strings. But what struck me was some of the reasoning from that initial panel decision in the Seventh Circuit. And again, very able judges, not ideological. This was Judge Rovner, saying things like, and I'm quoting, the public interest would be ill-served here by requiring simultaneous litigation of this narrow question of law in countless jurisdictions. And that to me is just another way of saying, like, well, we're stepping on the toes of the other circuits that are going to have the issue before them and are free to reach a different conclusion. The New York case had 6 states and New York City before it, and it wasn't, to me, obvious why a judge in Chicago should be determining the state of affairs for all jurisdictions across the country. And then one last related point, another strand of the reasoning was this pot of money is, just a single pot. And so the grants are interconnected, which, fair enough, except that Chicago would have only been better off with party specific relief, because then the strings stay in place for everybody else. And, it's, I don't know that there was really any risk of the money running out, but if that had been the concern, then that would have been a strong reason to limit the relief to Chicago rather than liberating every jurisdiction to dip into the pot of funds without having to meet the strings. So that's all I have for my 2 examples.
Great, thanks, Elisa. And that really is a helpful way of thinking, I think, more concretely about these issues. We'll round out the opening statements with Jonathan. Jonathan, any opening thoughts?
Sure. First, it's a pleasure to be here. It's great to be here with Elisa and Amanda and you, Adam, to talk about this issue, which has certainly gotten an increasing amount of attention. And it's as someone that's liked this question for a while, it's great that it's starting to receive the attention it deserves. Just in terms of framing some of the discussion and perhaps leading into what I know is going to be your first question to us, Adam, I want to say a little bit about kind of how this issue, I think, got some focus with regard to the APA, and then a little bit about some arguments I've made and the responses to those arguments about how we should think about relief under the Administrative Procedure Act. So as some folks are certainly aware, in United States versus Texas, and then also in Department of Education versus Brown, the Justice Department took the position that the APA does not provide, or did not create the novel remedy of universal vacator. That's the way that the Solicitor General characterized it in oral argument. And as some folks may recall, in U.S. versus Texas, this provoked quite the response. The Chief Justice characterized the SG's argument as fairly radical and inconsistent with fairly radical and inconsistent with those of us who were on the DC circuit 5 times before breakfast. That's what you do in an APA case. And all of a sudden you're telling us that, no, you can't vacate it. You do something different. Are you overturning that whole established practice under the APA? And I think if one looks at the way the discussion proceeded, both in US versus Texas and in the subsequent case, there was this split that appeared to be those justices that cut their teeth in the DC circuit, thinking that universal vacator, of course, had to be the remedy under the APA, and those who did not being more skeptical. And I've posited some possible explanations for this contrasting view, which I think relates to in some respects, how we got to this place, perhaps accidentally. So as an initial matter, as we all know, and those of us that focus on administrative law know, but it's always worth remembering, traditional approach to administrative law at the time of the APA's drafting was somewhat different than what we do today. Adjudication was, the modal practice more, across agencies more so than it is today. Legislative rulemaking was compared to today less frequent. A lot of the things that the APA was focused on were conceived of as having application in a world in which much of what agencies are doing is adjudicating issues, and the legal challenge would be to the orders that result from that adjudication. And I think here, as in a bunch of areas, as the traditional agency practice and how agencies operate has changed, we've not always had an easy time thinking about how an Administrative Procedure Act that was written in a different context and anticipating different sorts of legal questions applies here. And so in the context of orders under the APA, the idea that setting aside an order is merely setting aside what the agency did as applied to that particular party doesn't raise significant issues. And certainly for a long period of time, the understanding was the agency was free to maintain its underlying legal position and try again in a subsequent case, to engage in what we would refer to as non-acquiescence. And the agency would, of course, know, and federal attorneys would certainly be aware that there are limits to non-acquiescence. Certainly, if one is acting within or defending an agency action within the jurisdiction of a court that had already ruled against the agency, but certainly outside of those bounds, the agency would have some ability to persist. In the context of legislative rulemaking, where agencies are adopting rules with nationwide application, there are reasons to wonder about whether or not that same model applies. And I think some of the concern that arises is, if a regulation is supposed to have nationwide application, it should be standardized across the country. In fact, one of the whole reasons why we've seen a migration towards more rulemaking and less adjudication across most agencies is, at least in part, an effort to ensure greater clarity, predictability, and uniformity. And that value would be undermined if we did not have universal relief. I've posited that something else that's going on here is that, given the way jurisdiction works for where you challenge what agencies and when, in the DC Circuit, where a disproportionate share of pre-enforcement challenges to agency regulations have occurred, there hasn't really needed to be much thought about this question, because if one person can seek pre-enforcement review against an agency in the DC Circuit, everybody can. And so the precedential effect of a DC Circuit judgment against an agency will preclude the DC Circuit, or preclude the agency from being able to maintain its position. And to be sure, federal government lawyers are not going to engage in activity that could be considered as contemptuous of the court by persisting otherwise. And so even the question of agency non-acquiescence is not going to arise. And certainly during a period of time when the DC Circuit was seen as favorable territory in which to challenge agency action, you also had a natural tendency for folks to litigate in the DC Circuit if they could. And so I've posited that resulted in people just assuming, well, if you seek pre-enforcement review against the agency in the DC Circuit and you win, it applies nationally, because as a practical matter, it applies nationally. But there are statutes where pre-enforcement review does not need to occur in the DC Circuit, and we've seen the proliferation of litigants seeking pre-enforcement review in addition to challenging agency actions in other contexts. And I've certainly argued that as a historical matter, there's no reason to presume that the APA authorizes universal vacator in those contexts. There is a pattern or a practice of agency non-acquiescence, even in the rulemaking context. The examples that I think of arise from the environmental context. The Clean Water Act, for example, channels challenges to many rules into district courts, and so you can get variable district court judgments. So during the litigation over the 2015 WOTUS rule and the 2018 WOTUS rule and the repeal of it, there was a period of time where, until the Sixth Circuit finally issued a nationwide injunction, where different definitions of waters of the United States applied in different parts of the country. This wasn't the first time that it happened. Back in the 1990s, a district court in the Fourth Circuit had held that something known as the migratory bird rule had been improperly promulgated and was not a valid interpretive rule. And so for a period of time in the 1990s, that regulation or guidance, depending on what thought it was, could not be used in the Fourth Circuit. And that meant that the Army Corps of Engineers and EPA and Justice Department had to implement and enforce the Clean Water Act differently in the Fourth Circuit than in the rest of the country. In the Clean Air Act, there's a similar example of the EPA deliberately deciding that it was not going to follow a judgment in the Sixth Circuit about how to interpret portions of the Clean Air Act, when it then got sued for violating a separate regulation that said the EPA should endeavor to ensure nationwide application of its regulations. EPA's response was to repeal that regulation so as to at least maintain the option of agency non-acquiescence outside of circuits where there were adverse judgments. I should note, my explanation about why we see this disagreement is certainly not a consensus view. Ron Levin, in particular, has written a response that I think raises some points that are significant. I think he does note that there is language in cases going back some time that certainly suggests courts thought they were vacating statutes, particularly in the context of pre-enforcement review, and maybe that's limited to pre-enforcement review as opposed to challenges to the validity of agency action that occurs, say, in a declaratory judgment action or in defense against an enforcement action. He also notes that the whole practice of vacating and remanding and sending it back to the agency doesn't quite make sense if the rule still exists elsewhere. And I think that's a fair point as well. So I think that my bottom line is that there's a bit of path dependency that we see in the law here, and part of what we're dealing with is the fact that the way administrative law operates today, combined with the way litigants strategically seek to press their advantage in administrative litigation, doesn't quite fit with perhaps the language and assumptions that were in place at the time the APA was adopted, and that requires us to think through these questions more carefully.
Well, thanks, Jonathan. Let's stick with the APA a little bit longer if we can, just to set the table. I'd love to hear any reactions or further thoughts that Amanda or Elisa might have on how the APA's particular judicial review and remedy provisions should inform our broader sense of universal remedies. Amanda, I saw you nodding a lot during Jonathan's remarks. I'd love to give you the first chance to jump in.
So, I'll be briefer on this because I'm less of an expert and more on the non-APA forms of universal relief. But Jonathan's comments made me think of a couple things. One is, back when this debate was starting, and some scholars raised at Sam Bray, great work, although I disagree with a lot of it. He did great work, as did Michael Morley, in raising this issue. And if memory serves, both of them acknowledged that actually where a statute specifically provides for that relief, that is where Congress said a court can do it, that shores up the constitutionality of universal relief. I'm already on the side of courts can do this as part of their equitable remedies outside of the APA context. I think the fact that the APA specifically tells them they can set aside these unlawful rules gives extra force to the argument they have the power. Does that mean they have to exercise that power in every case? No, I don't think so. But certainly I would say it shores up the argument that in those kinds of cases, they have a congressionally sanctioned authority to do so. I'll also say, I think it's interesting in the ACUS report and the session on Friday confirmed something that I've long believed based on the case law and agency personnel I talked to, which is agencies sometimes really like universal relief. It is harder, they said, the ACUS report found after interviewing agency officials, to implement a patchwork set of injunctions. And it's practically impossible in cases involving clean water and clean air. The impracticability of saying, we're going to try to protect the plaintiff by stopping, some of the pollution of water and not other. I mean, that's ridiculous. You can't do it. So not only would it not provide complete relief, not to halt an agency action completely and universally, but also I think agencies would prefer that to a patchwork of geographic enforcement. Last point I'll make quickly is this interaction, Jonathan, you talked about between precedent and universal injunctions. I think it's really important to keep that in mind because, the Supreme Court basically, in a way, every decision is a universal remedy because everyone in the nation is bound, whether they're parties or not. Amy Coney Barrett wrote a really interesting article way back when she was a law professor about, does it violate due process if you're bound by precedent when you weren't a party to a case, but you live in the geographic region, whether it be the US or in a circuit, that suddenly is governed by a rule in a case you couldn't participate in? So I'll just point out that some of these concerns are really not universal injunction concerns. They're concerns about the force of precedent, and they're one and the same.
Hey, Amanda, that's a really interesting thought. Elisa, I saw your hand pop up. Let me just stick with this for 1 second. I hadn't thought in those terms before, what you just said a moment ago, Amanda, and I wonder about this. I mean, given that the Supreme Court is the Supreme Court, and it says in the Constitution there shall be one Supreme Court, and the rest of the federal judiciary is kind of optional. Which way does that last argument cut? I could see it seeing that actually it cuts against universal relief in the lower courts. I mean, not to put you on the spot, but that just occurred to me, and I'd love to throw that out there.
So I think it cuts forward when people make arguments that universal injunctions violate due process of the rights of people that are not parties, because that's what happens every single time the Supreme Court issues a case and we binding decision, or the DC Circuit issues one, or the Ninth Circuit issues one governing an entire region, and there are many people, not parties, affected by that. So I think it shores up the argument that universal injunctions don't violate due process when you think, well, but that's the normal result of precedent, right? So I guess that's my response to that. I will say one other point in response to what you just said. I do see that the Supreme Court, as the final court with the jurisdiction to issue a judgment that binds nationwide based on precedent, not based on the scope of the injunction, that suggests that some of that relief should come from the court. But I guess what I'll say is it does. I mean, when people say a single district court judge can control the law for the nation, that's a clear overstatement. It can immediately be appealed up to a 3-judge panel of a circuit court. They could go en banc, and the Supreme Court can review it. I don't think that should happen in every case, to be clear, but it's not like the single district court controls. It can be reviewed by the US Supreme Court.
Thanks, Amanda. Elisa?
Yeah, so the Supreme Court precedent, I agree, is really important to distinguish between a judgment and its preclusive effect and precedent, because a non-party might have to litigate up the chain, but they can litigate and ask the Supreme Court to overrule precedent. And we know the Supreme Court does that. So it's not, to me, a due process issue in the same way. And in thinking through it, I was interested to read the findings of the ACUS report, that what agencies and the clients would say, because my admittedly wholly anecdotal experience is quite different. It's basically that the client agencies want the option to decide, do I prefer uniformity, or do I, want to take the patchwork and accomplish my policies? That they see that like the CDC, when we had 2 decisions in I think it was both the Middle District of Florida, one judge upheld the requirement that people wear masks on planes during the pandemic, but the other judge not only said no, but said, I'm vacating it nationwide. And there were only a handful of individuals who had identified themselves in that case. It would not have been at all difficult to say, the same way other people had medical exemptions, like, okay, those 5, we know who you are. You get to carry your Judge Mizell exemption along with you on your flight. And that when I talk about keeping lower court judges in their lanes, part of it is keeping them out of the lane of the executive branch agencies that normally get to choose how to prioritize enforcement, whether it's we need it to be uniform, whether it's chaos, if it's, patchwork, et cetera, that's really not supposed to be the call for the judge as opposed to the executive branch. And then just the last point, going back to, I 100% agree with Jonathan about where we came from in the DC Circuit and the funky venue provisions that make the DC Circuit precedent special. And that is a practical matter, as like when we would advise our clients, if somebody lost in the DC Circuit and you thought the whole industry is kind of lined up on the same page and they're just going to bring lawsuits, there's no point in quarreling over whether it's universal vacator or vacator as applied to a particular plaintiff. But to me, the tax credit litigation, it gives the lie to the concept that there's something else special about the DC Circuit. Because as I said, like around the country, there were a total of about 5 people who were going to bring lawsuits to challenge tax credits. 4 of them had already brought it in Virginia. And then you had the one plus a few with outstanding in DC. And so just going back to national mining, Judge Williams' opinion that is often cited for the proposition that universal vacator is the default approach, he was really weaving together a bunch of distinct concepts and very explicitly said, in our circuit, there'll be a whole lot of follow-on lawsuits. And that's a precedent point. That's not a point that suggests that, the 600 district court judges should each have the power to rule universally.
Jonathan, since you kicked this part of the conversation off, I'll give you the last word. Any sort of further thoughts on the APA side of things before we go a bit broader?
Sure. So I will confess, that I'm personally, I am sympathetic to the position that the Solicitor General has put forward, and in the academic work, it's the position that has probably been more forcefully put forward by John Harrison, and that set aside has that was not understood to mean vacator as in render something to be a nullity. But I think it's important to understand that was also, I think, premised on those provisions focusing on what happens in the context of judicial review or adjudication. So that's my personal view of how the APA should be interpreted. And I think the practice of agency non-acquiescence suggests that giving agencies that choice of deciding, especially inter-circuit, what they're going to do is consistent with that, right? I mean, because we would hope if an agency loses a case, that the agency thinks about why did we lose, and maybe we were wrong, or maybe we're right, but we're not going to convince anybody, or we should think about this more carefully. But there will be cases, and I gave the Clean Water Act and Clean Air Act examples, where the agency is going to say that court's wrong, and it's important for us to maintain our interpretation of the law elsewhere, unless and until such point as the Supreme Court holds otherwise. The last point I'll just make on this is when it relates to the precedent point in the Supreme Court. I suspect one reason we also don't have more clarity in this space is, I guess it was Amanda who pointed out, when the Supreme Court decides, it is in effect a nationwide judgment. And so the Supreme Court doesn't have to really think about these questions, because once it's decided the merits, all of the remedial stuff as a practical matter follows. And so the Supreme Court isn't really thinking about, okay, the next time this scenario arises, what guidance do district court judges need, or do circuit court judges need about these questions? Because those questions are no longer relevant once the justices are issuing final judgment. And I selfishly would like the justices to nonetheless take the opportunity to provide more guidance, because we get, each time this comes up, by the time it gets to the court, these questions wash out and the court simply focuses on the merits.
Great. I just want to point out, folks who are watching at home, please do continue to submit questions. We've got 2 great questions already from Bill Funk and Joshua Sarnoff. Bill, we'll get to your question about standing a little bit further down, and Joshua will return to yours a little sooner. In fact, Jonathan's last comments there, I think, brushed up against the question, but we'll grapple with it directly. But first, I want to sort of expand the conversation now beyond APA to the broader themes of universal relief. Amanda, we'll start with you. In your opening comments, you said something I jotted down. The way you initially framed it, that universal relief can be useful or more than useful, really crucial in some cases, but generally, if I'm putting this correctly, generally you think they're overused. Maybe explain that a little bit more, and maybe map it onto some broader doctrines of relief and equity, and we'll go from there.
Yeah, so I have a couple thoughts on this. One, I'll just repeat that I think actually before this conversation started, thanks in part to academics, in part to the Supreme Court getting concerned as well. Before that conversation started, I think district courts sometimes were issuing nationwide injunctions quite thoughtlessly and too frequently. And I would look at cases where they would say, well, this is a federal law that applies nationwide, so therefore I should enjoin it completely and as to everyone. And that doesn't follow for me. Or we need complete uniformity in the application of federal law in all cases. Again, that is not required. That's not how our judicial system is set up. And I don't think that was a good rationale. But that said, I am a proponent of nationwide injunctions. I would be very concerned if they were to disappear altogether, as it looked for a little while like there was a debate about their constitutionality. I feel like that has now waned. And here's why. So first, just briefly, the idea that it's actually quite useful to agencies at times to have nationwide orders that they then apply nationwide. The patchwork of injunctions was not working for agencies either, as in some cases involving clean water, clean air, as I mentioned, and as I think the ACUS report also supported. So that's one type of case. Another type of case, and I'm guessing we all agree on this kind of case, is where nationwide relief is essential to provide complete relief to the plaintiff. So just like a sort of easy example would be an African-American child sues to attend an all-white school. It's not relief to say you and you alone can attend because it violates equal protection. It's got to be that the order now requires integration of the school. And as an aside, for those who say that's what class actions are for, class actions have been cut back and limited and are very difficult to access now in certain types of cases. So I will say that as a caveat. Where they are available, great. But where they're not, I want to see nationwide injunctions. But here's my third type of case where I'm quite concerned at the idea of losing nationwide injunctions. And I believe they're very important. And it's when they're essential to prevent irreparable harm to similarly situated people who cannot quickly sue. So I have two paradigmatic cases. One would be a president who comes into office and issues a sweeping ban on all entry into the United States by non-citizens. Very difficult to bring a class action, very difficult for anyone outside the US who's not a citizen to get access to a lawyer in our legal system. And the idea that each and every person would have to sue for themselves in order to get entry, rather than to decide as a nation quickly that they have a right to come in. That to me would be a huge grant of lawless authority to the executive to do something blatantly unconstitutional with very little recourse. A second quick example, it's election season. What if something like the SAVE Act, which is not about to become law, but would require proof of citizenship to vote? What if something like that were put into place 11th hour right before an election? Again, I'd be very afraid if each and every voter had to sue and we couldn't find some way to get universal relief to those voters. So that's where I think it's essential to curb and check the executive branch.
Thanks, Amanda. Elisa, any thoughts on this broader question of the doctrines and rules governing universal remedies beyond the APA?
Yeah, I remain a skeptic, even though in concept, and when I say universal, again, I'm talking about against a federal agency nationwide, not a school desegregation case where I conceptualize the constitutional right is to attend an integrated school. That's a little bit different. Mm-hmm. So there certainly are important issues that I think need to go to the Supreme Court fast. And, I certainly hear Amanda on ones, particularly when you're talking about a change in the status quo, that's something that you would hope the Supreme Court would be willing to address quickly. That to me is a very different issue from whether an individual judge, and we've got about 600, should be able to shut down policy universally, as opposed to giving relief to the individuals who are before the judge. And I do think there are a bunch of doctrines, withstanding the Supreme Court in the Alliance in the Mifepristone case, quoted Justice Scalia's memorable line, standing, you normally say, what's it to you? And so I would think that's an essential first question before the judge is going any broader than giving relief that in the tailored sense is redressing the injury for the plaintiff. And that doesn't mean sometimes you really do need to go somewhat beyond the plaintiff in order to make the plaintiff whole. But I haven't yet seen a persuasive example that there's a universal remedy that's necessary in that context, at least for federal agency rules. And then, of course, in the Starbucks decision from last term, which involved the NLRB's injunctive authorities, the district court's authority to issue an injunction at the behest of the NLRB, the Supreme Court said for equitable remedies, we interpret statutes to carry forward traditional principles of equity. And that's how I see, particularly the debate over vacator. I like the Jonathan Mitchell approach, which is that, sure, set aside can mean vacator. That doesn't answer the question, vacate as to whom. That's a remedies question. And so you could vacate it as applied to the individuals who brought the suit. And indeed, you would have to do that if they brought a legal theory that only applied to them. And there's no reason, just because their legal theory is general, as the Supreme Court in Corner Post said, that doesn't mean the cause of action is general. And then due process, this is where the litigation over the FTC's non-compete clause rule kind of really hammered it home for me, because there was a number of cases, judges were going different directions until one judge in Texas concluded that the FTC did not have statutory authority to prohibit non-compete clauses in employment contracts, and didn't just say, I'm setting aside, vacating it as to the employer who's in front of me, but as to everybody. And that's a rule that, but for the Texas judge's order, a lot of employers liked. And like, if they're, trying to poach employees from other employers and got sued, they'd say, wait, the FTC rule allows that. Or for all the employees who are protected by the FTC rule, again, they're not parties. And so I do think there are very real due process concerns with having a judge in Texas with one employer in front of her adjudicating the rights of millions of employees and, hundreds of thousands of employers who are not parties to the case.
Yeah, I'm trying to think through how that last example would map on to one of the dichotomies that Amanda, that you had a moment ago. With the non-compete clauses, I mean, the number of employees that would be covered by non-compete clauses is astonishing. Also the number of employers covered by who benefit from those non-competes is astonishing. And I'm trying to think through whether that would be an example where a lot of employees would not be in a position to sue, and so universal relief might help streamline things, or not. Not to put you on the spot, but since that was your framework was the last thing in my ear before Elisa brought that up, I'm just trying to think it through.
Yeah, and I think one of the points actually to be made here is that this is what I would want a district court to do when it's thinking about what form of relief is available. And I laid this out in an article, in a 2018 article, which is they should run through some of these concerns. Like, is this the kind of government action that individuals who are affected by it could bring suits? Will this stop in its tracks litigation, or will a nationwide injunction allow litigation to continue? I'll point out the travel ban was two different courts weighed in on that, the Fourth Circuit and the Ninth Circuit, with different reasoning. Even though there was nationwide injunctions, the Supreme Court had the benefit of both courts' rationales. And the ACOS report mentioned, and it came up last Friday, the fact there's a nationwide injunction does not necessarily stop different courts from weighing in and giving their views. And I think that's a very important consideration for a lower court to take into account. So I guess to the degree there's lots of in the weeds stuff about the FTC non-compete clause, I can't respond to that. I'm not too familiar with the case other than the broad outlines. But that would be my point, that that's for a district court, just like it does with any other kind of injunction, to take into account the various factors that would support that form of equitable relief, and to be careful about doing so and have the parties brief it. There was a period of time when courts weren't even asking the parties to brief this. They should always be hearing from the parties before issuing this form of relief.
Great. Thanks, Amanda. Thanks for letting me put you on the spot for a second there. I just want to point out, we now have multiple questions from Joshua Sarnoff and Jeff Rosen on this question of, on the aspect of multiple courts granting relief or withholding relief, sometimes inconsistent relief. Joshua first asked if we could address how competing vacatur and non-vacatur judgments would be assessed by the agencies, right? The agency perspective of what to do with this. But then looking at the question of the courts looking at each other, Joshua asks, can and should district courts issue sort of anti-injunction injunctions, right? A judgment to counter the effect of another court's injunction. And then Jeffrey Rosen added, similarly, how should courts and agencies deal with inconsistent injunctions? I recall being struck, I think it was last year, and it might have been the FDA cases, right? Was it the right around the time that the judge in Texas initialed that first preliminary injunction against the FDA? I believe there was a parallel case in Washington where somebody fix this if I'm getting it wrong. The judge issued an injunction in completely the opposite direction, sort of ordering the FDA to take the opposite action. Jonathan, you've not weighed in on this part of the conversation yet, so I'd love to hear your thoughts on anything that we've discussed so far on this, but also including the question about competing courts. And then Amanda and Elisa will circle back to you.
Yeah, no, and I wrote about the competing litigation, and I think it illustrates why we want to avoid that scenario. I mean, yes, there was a separate suit filed by blue states seeking to force the FDA in the opposite direction. And if you look at the way the claim was filed and the basis for standing, it starts to get really contrived. And we're channeling judicial and legal resources into this strategic gamesmanship about what kind of injunction can you get and so on, which, I don't think that's not what we want the rules to encourage. I think that some things to keep in mind is that just as, the lack of universal relief, at least under the APA, can lead to agency non-acquiescence, it can also lead to agency acquiescence, right? And that will, for ease of administration, that will often be what agencies will do, that at least temporarily they'll say, hey, we've lost, we want universal rules everywhere. We want to be able to tell all our attorneys to do the same thing. We're going to go with this until we come up with a better way of advancing the policy we want. I think that's important to remember. I think in at least some of the cases that Amanda raises that she, I think, is very rightfully concerned about, we have to remember there are other things out there that affect the decision, say, of a local school, right? So there are, in extreme cases, the risk of contempt, especially for the lawyers that are pushing arguments that they know we're going to lose in a relevant jurisdiction. There are certainly in some contexts, against some government agencies, things like attorneys' fees and the like can be a function of, in effect, how good faith the arguments are. So I think there are some other things that are at least part of the picture and may address some subset of those cases. I would note, on the other hand, there are contexts, immigration law being a good example, where relief that's not universal. If you don't have a single policy for the border, you don't have a single policy for the border. And I would say, ultimately, I would prefer that some of those judgment calls be made by Congress and not by the courts. And this may be a function of playing so much in environmental law, where if you look at some of the statutes, Congress very clearly made very deliberate choices about what sorts of rules should be challenged where, with an eye towards what needs to have nationwide uniformity and what can we allow to percolate the way adjudications orders arising out of adjudications would. So one example, under the Clean Air Act, all rules of nationwide application and scope must be challenged in the DC Circuit, whereas challenges to SIP implementation as a general matter get filed locally. There is a cert petition pending to try and clarify some of that. The Clean Water Act adopts a different approach. And I think it'd be good if Congress were to do that. Last thing I'll note, ACUS did issue this recommendation in June, which suggests that at least for pre-enforcement review of agency actions, the norm should be that those cases are filed in circuit court. And we know, as we saw in things like the OSHA vaccination rule, that when you get multi-circuit litigation of that sort, you can then consolidate those so you get a single judgment. So I think we can deal with a lot of the concerns about where do we and do we not want nationwide relief legislatively, and that would certainly be my preference for how we address those concerns, rather than leaving it to litigants to make the case for a district court to go big or go home.
Yeah. Thanks, Jonathan. Lisa, Amanda, any thoughts on this? on this
Just-
very, very broadly, I guess I do want to stick a little bit with the question about competing injunctions, competing vacatur and so on, or inconsistent judgments, or if you'd like to respond to anything else we've said so far in this segment.
Well, I just as to the conflicting or competing injunctions point,
Yeah.
I guess I'll respond just by zooming back the lens a little bit and pointing out our judicial system is one that allows for very intentionally jurisdictional redundancy. So that issue of competing injunctions is not limited to the nationwide injunction context. During the same-sex marriage litigation, as it percolated up to the Supreme Court, we had, I think it was Alabama, like the local court saying can't give marriage licenses to same-sex couples, and a district court saying you must. And we saw in Florida with some abortion debates back in the day, the Florida State Court saying one thing, the 11th Circuit saying another. So I'll just point out that problem of conflicting, competing, the tension, that's part of our judicial system. Second thing I'll point out is since I've been thinking about this issue, which is like 2017, there's been this great fear of the problem of conflicting injunctions, particularly when we had an 8-member Supreme Court, when it was like, we might not get a result. I hear that, but I have to say it's not happened. We have some conflicts, but courts step back. They are supposed to, under their doctrines of equitable relief, adjust their injunctions to deal with a conflicting injunction, and the Supreme Court can and should step in. So I guess I'm less afraid of that than others. I hear the concern, but I'm less afraid. And I guess the last point I'll make too is whenever I'm litigating these issues, and I come at this from someone who sued the government under, by the way, Alan Morrison, who's on this call. He was the leader of the office when I was at Public Citizen. I know Lisa and others come from the perspective of government attorneys, but my perspective is I sued the government and I watched them try to moot my best cases. I would bring a case that was clearly we were going to win, like on the merits, couldn't be clearer. And they would like undercut each and every plaintiff. And I feared the federal government. It's a very powerful litigant with lots of options. And I am not sure without nationwide injunctions, I can get my great, case about unconstitutional executive action before the Supreme Court, at least not quickly. And that's partly why I value them.
I'll have to admit, man, it's stepping out of my moderator role. As somebody who used to represent private clients, very sympathetic to what you just said a minute ago. Elisa, as somebody who's dealt with these issues, not just in theory, but in practice, litigating with the government, I'd like to interject one of Bill Funk's questions now. Bill, in this last part of the conversation, asked, can't the routine staying of the court's decision pending review by higher courts, so the fact that higher courts, including the Supreme Court, are now very well equipped and energetic to stay lower court decisions, could that help to solve some or most of the problems that we've sketched out so far regarding universal injunctions or inconsistent judgments? I mean, the district courts can move very quickly, but so can the appellate courts and the Supreme Court. Is that maybe a way to tamp down practically some of the problems that we've discussed so far?
Some, but not enough. Just because of the volume. Because like going back, I agree that it's not that we see a ton of conflicting injunctions. I agree with Amanda that that's a rarity and that the mifepristone example was unusual. Probably the frustration is, we could win in a whole bunch of district courts, and then it just takes one judge, like with the federal employee vaccine mandate, to say, I'm shutting it down nationwide. And then the Court of Appeals was unbelievably slow to try to resolve that. And then they take it on banc. And so, yes, in concept, the SG could go to the Supreme Court every time that happens, but in practice, they don't. It really, you can't keep going to the well that way. So that's like, without revealing anything deliberative, that's why you see a whole bunch of cases in which there's not an effort to get emergency relief, even though it is problematic. And if I'm just thinking back to that tax credit, the ACA tax credit litigation, if things had played out differently and we had to go to the Supreme Court on an emergency schedule, even though I always thought we were 100% right to say exchange established by a state, when you follow down the cross references, clearly includes exchange established by HHS when a state opts not to do it. It took a lot of work. It would not have been something easy to present on an expedited, kind of shadow docket schedule. And I think people just would have lost their coverage. So it comes at a big cost. and there's a lowest common denominator, which I don't mean to denigrate the one judge who decides against the government and rules nationwide. It's just, my point is, it only takes one out of the country, even if the agency is prevailing, quite widely elsewhere.
That last sentence sounds like a lot of the pitches to my clients back in the day. It only takes one judge in years, not just with injunctive relief, but questions around standing and justiciability, including state standing, which we've alluded to earlier, and the questions about representational standing, which Bill Funk raises in the Q&A. Elisa, could you kick off this last segment of the conversation about how recent developments around standing and justiciability map on to these, or dovetail with the questions about relief on the back end?
Yeah, and I absolutely, as I said at the outset, I agree with Amanda that these are two of the most important issues to consider in connection with universal remedies. And I also agree that the Supreme Court in the Texas immigration priorities case, clearly sent a signal that it's not inclined to accept state standing. That's what I think of as the kingdom for want of a nail chain of reasoning that would essentially allow any state or coalition of states to become kind of party in exile that brings down the executive branch policy based on indirect injuries. And on representational standing, my own view, and this is also illustrated in the non-compete litigation, is that it should be fine for a trade association or other organization to represent certain members, but they should have to get a list and, actually solicit, do you want to be bound, and then identify them early on. One thing we saw in the Texas non-compete case is that the American Hospital Association filed an amicus brief saying, we don't like the FTC's ban on non-compete clauses. And then one of its members, NYU Langone Health, came in and said, wait, you don't speak for us. Like, we want to be able to hire doctors without these artificial barriers to competition. And it just underscores that people in institutions join these trade associations or umbrella institutions for all sorts of reasons. And you can't assume that they can litigate in a representative capacity without some empirical support.
Lisa, on that last point, are you saying the upshot of that is that for a trade group or a sort of broader organization, when they litigate, they ought to say, here are the members who affirmatively join this position? Or are they saying there should be an opportunity for dissenters within the organization to be noted as dissenters?
I would say the first, again, for orderly process, so that everybody knows up front who is suing, who's going to be bound by the relief, win or lose. Sometimes you see these suits like we've seen involving the Medicare drug pricing reforms, where it seemed that all of the big affected pharmaceutical companies brought their own litigation, and then nonetheless, you would have Chamber of Commerce or Pharma bringing separate suits. And like, who do you represent? What's going on here? So I think they should actually have to cough up the list of who has affirmatively agreed to be bound and do it at an early stage, before there are merits decisions made.
Jonathan, any thoughts on this, on both this narrow question or just more broadly, how we ought to think about the standing and justiciability questions as they dovetail with these relief questions?
So, I mean, I think that the standing issues are important. I think, the court has realized it needs to be clear about this point as standing relates to a bunch of remedial questions, severability being another one. Standing is not dispensed in gross. I think the court is moving in the direction of both policing who has standing in the first place more aggressively, as well as making sure that, the litigants that have standing for each claim they wish to push, and that you can't kind of find some little thing to get standing on as a way of then getting into court for something else. And I think the court's moving in that direction. I think here again, though, I think I would certainly argue we want to be cognizant of preserving Congress's role. I think that, that the ability of Congress both to confer broader standing is or should be larger than at least I think some of the justices anticipated it being. And Relatedly, I think Congress can say a lot more about what sorts of relief on the back end can be provided, right? Congress could easily write a statute that says if a district court concludes the following under this statute, the agency is precluded from enforcing that action or enforcing that regulation until, further relief has been, further judicial review or what have you. Some of these questions would become easier if there was more legislative engagement with these questions, and we would have to be less worried about the courts figuring out how to balance all the various equitable factors in these contexts. My one concern in the standing area is that if the court is too restrictive on Congress's ability to define the contours of standing, that would get in the way of Congress being able to provide guidance in this range of issues.
Amanda, any thoughts?
Yeah, I'll just say one, I love this conversation because we've got Jonathan saying, power should be with Congress. Lisa's more about the executive branch. I'm more about the judicial branch. So we're all perfectly balanced here. And I will say this is a separation of powers question. Like the really big picture question is where should the locus of power be? In terms of standing, I agree with what other folks have said about the fact that the court seems to be taking a step back from this very broad idea of state standing. Certainly in Holland versus Brackeen, they said the state could not bring the equal protection claims of its citizens. I support that idea. I think this parens patriae, we get to sue for any harm to any person in our state, would be overbroad. I think it's a hard balance for the court to strike. It obviously doesn't want to get rid of state standing completely. Standing questions are always thorny, complex, and often inconsistent. I used to teach federal courts, so I was well aware. And I do think that that's one piece of this, rather than just say no universal remedies, to say, okay, we're going to keep some universal remedies, but we're also going to limit who can bring suit and the claims of injury that they can argue as a basis for getting into court. I think that's really important. Last point I'll say is, Lisa, I hear you and agree with you that ability of plaintiffs and their groups to bring case after case after case, finding the district court judge that gives the nationwide injunction, never precluded by the losses, that is a problem. And I would say maybe the solution is make it easier to bring class actions, because when you do that, then you are precluded. And maybe that's the better solution. And that would take us to Congress, which is, I think, where Jonathan would like us to be anyway.
Great. So we're almost out of time, folks. And I just want to swing through the group one more time. I'll just point out the title of this panel was Opportunities and Challenges. We've talked a lot about challenges, a little bit about opportunities. So maybe just in closing, we focus on, there's maybe just one reform you'd like to see, bonus points if it's a suggestion to Congress. I'll just say, as the panelists are thinking, I remain firmly attached to my little idea that if there were a law that would create a lottery, and anytime somebody went into a district court seeking universal relief, however defined, they could pursue it, but it'd get kicked out to a random district court. That would be one way to change the incentives around this. I'm sure there's all kinds of bad consequences that I haven't thought of yet, but I choose not to think about them. Why don't we just go around the horn really quick with closing thoughts or proposals for reform? And we'll start, I guess we'll go in the opposite order as we started. We'll start with Jonathan.
Well, I mean, I think for starters, Congress acting on the forum proposal that ACUS put forward in June, I think would be a start. I think Congress can even go farther than that. So that proposal suggests that when statutes provide for a judicial review of agency actions, it should go to circuit courts. If we assume, then therefore you're going to get the multi-circuit lottery to ensure that there's one circuit court handling it. That deals with some of these questions. And then I think, more broadly, though, it would be nice to have more provisions like we see in some of the environmental statutes I mentioned earlier that make clear kind of when, as a policy matter, uniformity and consistency is particularly important in that sort of context, because there are judgment calls to be made there, and I think they're ultimately policy judgment calls that the legislature is in a better position to make than courts are.
Great, thanks, Jonathan. Elisa?
So since I'm doubtful that Congress will spring into action, I'll throw in one last thought for the Supreme Court, which picks up on something Amanda said. I don't regard state standing as all or nothing. I think one thing the Supreme Court could do is focus on what relief can the state gets when it sues with a genuine injury. And so, for example, in the student debt case, they could have said, well, Mohala, which was the loan servicer that was an arm of Missouri, you can get relief, but that doesn't mean lower courts should be ending the program nationwide. And, of course, it's overtaken by precedent if the Supreme Court says the program is unlawful, but just focusing on remedy. This comes up for us a lot. States sue and they get statewide relief, even though really their injury might be, I have a state-run hospital or a state-run Head Start center that doesn't want to administer COVID vaccines. And, you could tailor the relief that way.
Yeah, and by the way, I would agree with that, which is that a district court should be very careful when it thinks about the breadth of relief and should have the narrowest form of relief possible, with the caveat of, is the plaintiff remedied? Is there irreparable injury to other parties, et cetera? So I think we agree, and I certainly think nationwide injunctions were overused in the past, although I think they're now coming into line with more of my thinking, not because of me, but because people have raised these issues more broadly. I will say the one reform I'd like to see, again, would love Congress to take action, but kind of lost some faith over there. The Judicial Conference of the United States has a proposal that's definitely more moderate, but would avoid the idea that you file in a single division where there's a single judge and you get that judge. And it is not clear to me how that's going to play out, but to the degree that that would allow for the more random assignment where you can't pick your judge, that would benefit both, I think, the entire nation on this issue, but also I think the courts are really losing some of their status and reputation among the American people. And part of it is because of this politicization of the judiciary. And this would really help shore up the courts, which is another reason I like it.
And the ACUS recommendation that was alluded to earlier, just for folks who don't know, my guess is the people who are on this call know, but if you don't, it was titled Choice of Forum for Judicial Review of Agency Rules. It was published in late June. And with that, I want to thank all the speakers and turn it over to ACUS's chairman, Andy Foyce. Andy, you still there? Great.
Thanks, still Andy. Here, Adam. Well, that was just terrific. Thank you all so very much, Adam, Elisa, Amanda, and Jonathan. And thank you also to everyone for tuning in. This concludes our two-part forum on nationwide injunctions, their impact on federal regulatory agencies, and their opportunities and challenges. We hope that everyone enjoyed them. Both panels of this forum can be seen on our website, acus.gov, and a direct link to the forum has been placed in the chat today. While you're at our website, take a look around. All of our work product is on there going back to 1968. Includes all our recommendations, our studies, our reference guides, resources, source books, and all sorts of other things. So please take a look at that. And while you're there, sign up for our newsletter, which will keep you up to speed on everything that we at ACUS are doing to help government work better. So thanks again to all the panelists and to all of you. And have a good afternoon and goodbye.